Hello, my name's Rodger Citron. I'm a professor of law at Toro Law Center. This is a Toro Law Review podcast, and I'm delighted that we have for our guest today someone who I actually took a class from decades ago when I was in law school. He is Judge Michael Ponsor. I believe you are now a senior United States District Court judge.
That's technically true, yes.
And only by title, in no other respect.
Yes.
And we're here tonight to talk about your third novel, your third published novel, I should say, Point of Order, which was published earlier this year in 2024. And let's just start where we always do. Thank you, of course, for joining us. And please tell us a little bit about yourself.
Well, it's a great pleasure to be here and a great pleasure to see you again. I have very fond memories of teaching that class at Yale, and it's really great to wind around after quite a number of years. People are made up of all sorts of different components. Everyone is fathers, husbands, friends, professionals of various kinds. I suppose that the way for me to present myself is oversimplified, but I've been a sort of a writer and to use a Chaucerian phrase, a man of laws for my whole life. When I was 8 years old, I decided I wanted to be a lawyer. And I can't remember exactly how I came to that conclusion at age 8, but a neighbor said, "Oh, well, if you're going to be a lawyer, you should go to Harvard Law School." This was in around 1954 or 1955. So I wrote a letter to Harvard Law School saying, enclosing my report card from the second or third grade and saying that I was planning to attend, and I got a letter back from the registrar at that time who told me he looked forward to entertaining my application. First time I'd ever seen the word entertained used that way. I unfortunately didn't keep the letter, but I continued with this goal of entering into the field of law. But my life also ran on a parallel track and has ever since then. I've gotten interested in long narratives and writing. So I began actually writing novels before I formally entered the legal world. And I wrote a novel when I was at Oxford. In fact, I did not end up going to Harvard Law School. I went there as an undergrad, and then I went to Oxford for 2 years, and I wrote a novel while I was there, and it was picked up by an agency in New York, and it looked like I was going to veer off into the novelist stream of my character, but unfortunately, no one ever picked up the novel. And I went on to law school, clerked, practiced in Boston, moved out to Amherst, practiced in my own firm, became a magistrate judge in 1984 in our federal court in Western Massachusetts. And then in 1994, President Bill Clinton appointed me a life-tenured U.S. District Court judge, where I have been ever since. But all along that route, I'm writing novels, drafts of novels, short stories, and so the novelist part of me and the man of laws part of me were sort of riding along together all these years. And I published my first novel, finally, in 2013. Where 1967 came in there, I have no idea, but it was 2013. Oh, yes, I was 67 years old when I finally got a novel published. It did quite well. It went on to be a New York Times bestseller. And since then, I've published two novels, my most recent one being a novel called Point of Order, which came out here in March, just 3 months ago. So that's a very short thumbnail of a life with two disparate components, which have actually coincided or coexisted pretty comfortably together over the years.
No, you do, forgive me, you do contain multitudes. And yet there is a congruence and perhaps even an overlap. And I do want to touch on one thing in your biography, because it may lead us into the novel, or certainly part of this most recent novel, which is that you spent time in Kenya.
Yes.
And I'll just please tell us about that. And if you want, you can say to what extent, if any, you drew on that or were
Sure.
influenced by it in the novel. Mm-hmm.
I did quite a bit of traveling in my late teens and 20s. I lived in Finland for a year as an exchange student under American Field Service and lived with a Finnish family. And I was then when I was an undergraduate, I still had the travel bug, and I went to Kenya and lived outside Nairobi for a year, teaching at an institute there. I was only 20 when I arrived. I didn't think of myself as young then, but as I look back now, it seems I was very impressionable. And I think it was in some ways, even more than my year in Finland, it was my entry into a wider world. And what I was trying to do in Point of Order, as you know, there's a character in Point of Order, his name is David Kamau, who is a Kenyan and who becomes central to the plot. My first book was about the death penalty, which is a very, very difficult area of the law. My second book, part of the theme of it was to talk about child pornography and a defendant who's an academic and who's charged, perhaps rightly, perhaps wrongly, for possessing child pornography. And in my third novel, I try to tackle the issue of immigration. And my time in Kenya and having that exposure to people who have a quite different cultural background really opened me up to that. And I wanted to try and talk a little bit about the way the world is filtering into itself in this time that we're all living through. It used to be in the United States that we talked about the melting pot. People would come to the United States and then they would dissolve into, or their children or grandchildren would dissolve into the greater culture, the larger culture. Now I think it's much more a feeling of overlap, of tectonic plates meeting each other. And there isn't the same degree, at least in some ways, of melting, but of coexisting of different cultures and finding ways for us to live together happily. And that's what I try to tackle. And I think that experience in Kenya was a fuel for this particular theme that I try to address obliquely in the context of a story, which is hopefully fun and interesting and a good read. I try to talk about that.
Yeah, and maybe we'll come back to sort of, the imperatives of fiction as well as, politics broadly defined, and how you think about those things when you write fiction. But before that seems to be jumping a little too far ahead. The question I wanted to turn to, actually, let's go into the novel
Sure.
with Point of Order.
I love it there. That's fine. I'm happy in that world.
And you spent a lot of time there.
I sure did. Yeah.
And one of the things that struck me, having read your first novel, published novel, the first Judge Norcross novel, and then this one, I have read two of the three.
Sure.
Having a judge as a central character, which I think even from the start, even reading the first one this is really interesting because typically in a thriller, it's a lawyer or the client or perhaps both. In my generation, presumed innocent was sort of the paradigmatic. And of course, the central character was both lawyer and client. What did having a judge as the central or a central figure, how did that influence the fiction you wrote? That is the story that you wanted to tell.
Yeah, that's a great question. And I found as I was drafting the first novel that some people would say to me, you can't have a novel with a judge at the center. A judge is too static. He sits up there. He occasionally says sustained or overruled or counsel approach the bench or, behave yourself or whatever. And he's this sort of obscure, opaque character. And of course, that is exactly the opposite of the experience that I had, and I think all judges have when they're actually up on the bench. It's an extraordinarily dynamic role, and you are 100% alive sitting on the bench. You're obviously paying careful attention, let's say, in a trial to a witness's testimony. You're getting a sense of what direction the testimony is going, whether there's an objection in the offing. You're watching the body language of the attorneys. Are they rocking onto their toes to get ready to get up? Who's that person coming into the courtroom right now? I told the witnesses they're supposed to be sequestered. Is that a witness somebody forgot to tell? They're not supposed to be in the courtroom. Why are those two attorneys muttering to each other in a way that's just loud enough for the jury to hear, but not loud enough for me to hear? Juror number 4 is falling asleep again. I have to go to the bathroom. When are we going to take a lunch break? All these things are going on while you're up there, and you are alive on a sort of basic sensory level, but also on an intellectual level, and in some ways on a moral level. Because one of the things about being a judge that I discovered in writing the novel, one of the things someone said about writing is that you learn what you already knew. And a judge judging, the act of judging, is a kinetic art. It's like dance or theater. Your posture, your tone of voice, your facial expression, their whole attitude creates an atmosphere where justice is either possible or impossible. All you have to do in a trial, when a key witness is testifying, to destroy any hope for justice, is just look over at the jury and roll your eyes with an impatient look on your face and communicate to the jurors in a way that will never enter the transcript that you don't believe this witness and you're impatient having to listen to them. And at least some of the jurors will pick up on that. And if they don't, you can do it repeatedly, possibly. So the judge is this pivotal figure, and you're, this is just a metaphor, but you're almost glowing with the energy of that. So a story told from the perspective of the judge who is trying to create an atmosphere where justice is possible is very dynamic. And I've enjoyed doing that.
This will take us into, and I'm not suggesting it's a one-to-one correspondence or correlation, but the character of Judge Norcross. And I think there's two things that struck me. One, from what you just said, and again, you said something that I probably did already know, but the performative aspect of being the judge. That is, it's a three-dimensional engagement role, that you're taking on. And then the second is, when we talk a little bit about Judge Norcross, there was, as written, I read him as very attuned to what you were talking about in terms of not only deciding, but appearing to be decisive. And then the last piece, which I also struck me as, and this is what I bring to it as the reader, is one of the things that struck me as very believable about the judge was not being introspective. that is important to part of being decisive is actually being decisive and not being ruminating and so on. And
Mhm.
so, with all of those predicates, can you tell me a little bit about what went into creating Judge Norcross?
Yeah, I think you're right. Judge Norcross is an introspective man in certain ways. He's very aware of the problems of a system of
Hmm.
justice and the flaws in a system of justice. He's very aware that he is doing things that are highly questionable from a moral point of view, imposing a mandatory minimum sentence that he knows is excessive, sending a perfectly nice Kenyan man right at the beginning of point of order, deporting him and separating him from his children who are American citizens born here in the United States. So he's introspective enough to know a lot about the moral complexity of his position, but he also has to make calls fairly quickly. That's one of the things that a trial judge has to do. You can't dilly dally. There's a phrase that I learned when I was just becoming a judge, and I repeat it in point of order, where Judge Narcross is coming back to his chambers after having sentenced this man for illegal reentry. And he says, well, time is your friend here. I feel very ambivalent about what I just did, what my role required me to do, but in a few days that will pass, and I'll move on to even harder things that I have to do. And as a colleague of his and as a colleague of mine told me, rule and roll, rule and roll. You've got to make your rulings and you've got to roll on to the next one. And some of them may be, in retrospect, hasty, but you can't get yourself caught up in that. You have to rule and roll. My old boss, who I clerked for, used to laugh and describe his judicial style as often in error but never in doubt. And that's another motto. I mean, you have to be clear, and you have to be fairly emphatic, and you have to make your decision fairly quickly. And that doesn't mean that an introspective person can't do the job. It's just that you can't get too caught up in that side of your personality when you're trying to conduct a trial. Yeah.
And then I left out, and of course you reminded me that as a person that is in his private life or in his private thoughts, the judge, in fact, is very thoughtful,
Mm-hmm.
and aware of either the ambiguities or even worse, that is to say, the at least equitable injustices that the job may create. This is, for me, I don't know how hard to press on this, but I've always been interested in Herman Melville and Billy Budd, and of
Mm-hmm.
course there's an extensive literature over you know Captain Vere and where do we locate Captain Vere? Is he Melville's father-in-law or not? Anyway,
Mm-hmm.
in any way, I'll just to try and sort of connect the two. Is there a connection between the two for you? Did Melville, Vere, Billy Budd in any way? Do you think
Yeah.
influence come into your thinking, or if not for the novel, perhaps
No, I
in other
think that
context?
the Billy Budd plot uh, does bring to the surface a central problem with any system of justice. It used to be, when I was an undergraduate and everybody was a Marxist long, long ago, and I think you may have experienced that too when you were an undergraduate. And people talked about critical legal studies and how the American system of justice is this or that. any system of justice. The Billy Budd is the British system of justice, it so happens, and a military system of justice. And so you have Captain Veer, who's in a position where, similar to where an American judge is. He has a mandatory minimum sentence. A mandatory minimum sentence for Billy Budd is death. He's hit a superior officer. You hit a superior officer. It's in the context of where there have been many mutinies, and they come down with this rule. 50 grams of crack cocaine plus 2 priors for a violent or drug-related felony is mandatory life, and that's what it was at the time that I wrote The Hanging Judge. It's a horrible sentence. It's ridiculously excessive, and the judge has no discretion, and Captain Veer has no discretion, and he recognizes the humanity of Billy Budd and Billy Budd's functional innocence, in the sense that he was goaded into a response by a sadistic superior, and reacted without thinking. And in a outside of military tribunal and outside of that particular context, he may have been able to argue various things to avoid the death penalty, but in that context, it wasn't possible. So I've been in Captain Veer's position. Fortunately, I haven't had to order somebody to be, hung by the yardarm, but I have had the responsibility, and pretty much all my colleagues on the federal bench have had the responsibility of being forced to impose a sentence that is excessive, and you do it, or you resign. And so, yes, there is an overlap. I have to say one thing, though, and this maybe sounds peevish. I've gone to many programs on law and literature, and 2 works of literature are always featured: either Billy frigging Budd or Measure for Measure. It's always that. Shakespeare's play Measure for Measure. One or the other of them is always the center. I think one of the reasons Billy Budd is frequently chosen is it's not too long, and people will read it before they come to the seminar, and there's a lot to talk about. So, but I always thought the world of law and literature is a lot more interesting than Billy Budd and Measure for Measure, as interesting as those plays may be. So, yeah.
Oh, I'm going to ask now before I forget, but I'm only going to give you one. What would you assign instead if you were conducting the seminar or asked to lead the program?
Now that one really puts me on the spot. I think I might pick another play like Hamlet, or possibly Norman Mailer's book about the gentleman who was executed in Utah.
The Executioner's Song, Gary Gilmore.
The Executioner's Song. Although that's a doorstopper, it's so long, and the people who are involved are so repellent that it's hard to spend that much time with them. I think what I would be looking for, and I'm not sure I can come up with a good example, but my point is, or the point that I would be trying to make is that law is, in a broadest sense, fiction. It comes from the word facere, to make. The principles of law emerge from the deepest recesses of the human imagination, and they sustain themselves by our belief in them. So when you think about a concept like equal protection, or a concept like due process, and you look at it and you try and, to use a proper phrase, drill down. What do we mean by it? Nobody believes in equal protection. What are you talking about? Lawyers and judges talk about it. But what do we really mean by that? And how does it work? It's impossible. Due process, people lose things without due process all the time. And yet we have this made up notion that we can try to create a system that actually applies those principles that are so precious. And the effort to apply them is so courageous. But they are unreal. Not that they're false. They aren't false. They're as true as anything about us. There's true as the 5 fingers on my hand. But they are products of the imagination, and they become real as they come alive through the intensity of our belief in them and our allegiance to them. And so the bedrock principles of our legal system are the products of the deepest imagination, and the same source of imagination that produced Hamlet, that produced Huckleberry Finn, that produced Pride and Prejudice, that produced A Tale of Two Cities, is the same source of imagination and creativity that produced the concepts of due process and equal protection. I don't know that I can prove that, but I believe it.
That would lead to res ipsa loquitur. At least as a concluding point, I will say I'm going to exercise questioner's prerogative just to add for 20 seconds or so. You're absolutely right about why Billy Budd gets assigned, which is that it is manageable. Not 800 pages of whaling. But I actually, when I taught the law and literature course, to get the students warmed up, because still 19th century and Melville, if you haven't looked at it in a long time, it can be hard. The language, it can be sort of off-putting just until you get sort of assimilated into the language. So I would have students start with a Russell Banks novel, The Sweet Hereafter, which was made into a phenomenal movie. It's a very good novel. The movie might be one of the rare instances, I think, when it's arguably better than the novel, which is not to disparage the novel in any way. And it's all about the notion of fault in tort. And so we can say more, but I guess I wanted to agree with why is Billy Budd so popular? Because you can read it and it won't take too long.
And it does bear down quite hard. A central problem with the system of justice, and that's great.
And I think that yes, and the construction, that is to make it so stark. Yep. There's no mercy, there's no mitigation, there's no equity. It sort of strips away to these sort of core questions about what can Vere do, if anything, and not much.
and you also have that wonderful ending with Billy Budd, who reaches through the judge to the person when he says, "God bless Captain Vere," and he knows that Vere is more than the man who condemned him. And I think that's very moving and hopeful that he's able to do that. Yeah.
Yes. Let's go back to you and point of order. And there was, I know that when we talked earlier in the week, just to about tonight, there were 1 or 2 scenes that we discussed, and I say that only because one scene that especially stood out for me was the opening statements, and in particular, the defense attorney's opening statement, because he is so hyper aware, hyper focused. There's at one point, I don't think this is giving anything away, but he hears the judge pouring a glass of water, and it's on his mind, but it's on his mind of, is he trying to interfere with me? Is he trying
Yeah,
is he trying to signal? And he says, no, he's not. He's probably just thirsty.
yeah.
Um, and I that hyper awareness. Um, I, did you have that when you were an attorney? How conscious? Well, I think you've told us a little bit about how conscious you are.
Yeah.
As a judge, how do you manage that? I guess there's sort of two questions. One is, did you have that experience as a practicing attorney? And then the second is how you manage that sort of hyper
Right.
awareness as a judge.
Yes, it is it's a big part of what makes the judging so dynamic, because you have to control yourself, your expressions, your tone of voice, and so on. Tarbell is addressing the jury, and he is building to a point in his presentation, which is critical to his argument that the defendant can't be proved guilty and is in fact innocent. And just as he's about to have his big moment, there's this gurgling noise in the background, and he thinks, is Judge Norcross trying to cut the legs off me here at my high moment? And yes, a lawyer is going to be very aware of that, and he's worried about that. And then he thinks he's probably not the kind of judge who's going to do that, but he's forgetting for the moment how important everything he does is. And I had a trial one time where I had a very aggressive defense attorney, and he was questioning a witness, and I was puzzled about some of the testimony, and I broke in with a question to the witness, thinking that I was just asking the witness to clarify something. And the witness went farther than the clarification and said something that really just killed the defendant right there. And I made an enemy of that defense attorney for the entire trial, because he decided, and I could see it in his face, that I was out to get him. And I put that question to the witness in order to make him look bad in front of the jury. And he fought me from then on. I was his adversary. And it was unintentional. I think I would ask the question again. I might phrase it a little differently, but I had no idea that the witness's answer was going to be so devastating to the defendant. Fortunately, about 3 days later, we had to mistry the case because it turned out the government had not provided documents prior to trial that I had ordered them to provide, and the defendant was badly prejudiced, and I had to mistry the case, and we had to start it over. So he got a free throw from that, and eventually got an acquittal, which he probably was entitled to. But you have to be careful. Every little thing you do. When I was practicing in Boston, and I was second chairing for a lawyer who was a prototype for Bill Redpath, who was a key figure in my first novel, he had a judge named Roy, long ago passed away, a Superior Court judge. And Roy was, at least from my boss's point of view, out to get my boss in every trial. He would do everything he could, from facial expressions and recessing early and postponing things, to make it hard for my boss to present a defense. So there is that tension, and people are going to be worried about it.
And this is, I think what we're talking about is adjacent to another scene that, which I again was struck by, your ability to translate the stakes for the reader about what was going on. And this is a scene in which, again, I don't think it's too much of a spoiler alert, but the key witness for the prosecution is testifying, and essentially, either without a question pending, I think without a question pending, or appends to an answer, a very incriminating statement,
Right.
fairly subtle. That is, it's it's really well done. That
Hmm.
is the sophistication with which the witness is doing what he's doing. And then, of
Yes.
course, there's this dilemma for the judge. And I even, we talked about it, and then I reread the passage, and then I said, because I think I was interested in sort of, if we go out of the novel back into your experience as a judge, what would you do, or how do you handle those situations? If I can also add in the novel, and this is what I reread today, which I had not thought about, um, he does something that at least the appellate court will see that the rules were followed.
Yes.
Also reads as unsatisfying. That
Yeah.
is, and so, um, whether as an author, whether as a judge, I'd just love to hear your sort of, what went into writing that scene, and then perhaps as a lawyer, and just,
Hmm.
how you think about the dilemma that's created or the challenge that's created when something like that happens.
Yeah. Well, there's uh, uh, yes, the scene you're describing, the key witness for the prosecution is a guy named Shaughnessy, who was a dying professional killer who's come to testify for the government in order to help out his nephew, who was being charged with other crimes. And the defense is that the defendant, whose name is Dominic O'Connell, never even met this guy, had nothing to do with this guy. He's being the defendant in my trial, the trial in the book, is charged with having been the wheelman, the driver, in the murder of a Boston cop. And Shaughnessy is there to say exactly what happened at the murder and to put the finger on O'Connell as the driver. And he's testifying, and he says the government says, "Did you ever meet Mr. O'Connell?" And he says, "Yes." And it was when we riffed the cop. And then he says to O'Connell, "We didn't get along too good that time, did we?" Not in response to any question, but just out of the blue, or something like that. You probably remember the exact phrase better than I do. And O'Connell reacts in a way that, if you were watching carefully, blew his whole defense, because it was very clear by the way he reacted that they had met before, despite his denials. And of course, Tarbell, the defense attorney, is on his feet, instantly moved to strike. So the judge has got a dilemma, and all judges have this dilemma when something comes into the record that you want the jury to ignore, and you want to order them, instruct them to ignore it without putting an underline. So you can't say, "Okay, ladies and gentlemen of the jury, don't pay any attention to that part about where Tarbell said we didn't get along too well. Yeah, put that out of your mind. The getting along too well thing, you shouldn't think about that at all." Well, you could just say it, and you know how hard it is. But at the same time, the Court of Appeals is looking down invisibly on this trial, and a judge has to give a corrective instruction at this point. So how do you do that? Well, you fudge it, and you say something like, "Well, Mr. Tarbell, Mr. Shaughnessy threw in some kind of remark about they're not getting along," or something like that, but you should just not pay any attention to that. That's not relevant. And so you try to touch it lightly in a manner that'll help the jury to know what you're talking about and make it clear to them that it's out, and you don't want them to consider it, because on the one hand, the Court of Appeals is going to want you to identify very clearly exactly what it is they're not supposed to pay attention to. And from the defense and from a practical justice point of view, you don't want to put it in bright lights. So that's just a kind of typical thing that's going to happen constantly if you're trying any cases. That kind of point is going to come across. I can't remember any particular instances from when I was practicing before I became a judge, but I know it is just an example of a sort of, I don't know, trial practice 101, where those kind of things happen and you have to deal with them.
Yeah, it's a anyway, the scene reads very, it's just so well.
Well, that's one of my favorite scenes in the book. It comes towards the end, and I enjoyed creating the character of Shaughnessy and that whole scenario in the courtroom.
I want to pull back a little bit, sort of, but still with point of order and thematically. This was something that when I thought about, after finishing the novel, I I think so much of in the law and literature context, we think about law as being instrumental, as imposing order, as helping society organize itself. Um, and so I think that, for Judge Norcross, that's an important part of performing his duties as a judge. And yet there were, I think, several times in the novel when serendipity, if you will, um, uh, either disturbed or undid, or the best laid plans or the best intentions in terms of order when that occurred. And I guess my question is, how much of that was sort of intended in the novel to sort of you know contrast, the sort of the desire for order or control, with the fact that, as broadly as possible, right? Life's a very contingent exercise, and I'll just leave it at that.
That's an excellent way to put it. Yes, attempting to cabin reality in a system of principles and then hold that together for long enough to allow those principles to adhere is one of the hardest tasks of judging. And for example, the recent criminal trial in New York involving our former president, I just had enormous respect for that judge for just being able to hold it together and move from point A to point B to point C and get through the trial. In terms of judicial craftsmanship, it was an extraordinary demonstration of skill and dedication and, frankly, courage. Nothing like that's that hard has ever happened to me, but something nearly that hard happened when I had to preside at a death penalty case. And the defendant is sitting right there in the courtroom, and we're deciding whether she's going to be deliberately killed. She was a nurse at a Veterans Administration hospital charged with killing several of her patients. And so there is caprice that enters in. We had one of the lawyers had a heart attack or had some kind of heart ailment. He had to be hospitalized. We had jurors about the flu. I had once, not in that trial, but in another trial, I had one of the jurors step out of the witness box, forget there was an extra step, and break her ankle right there in the courtroom. I've had lawyers throw up in the courtroom, or jurors throw up. They get the flu and they decide to tough it out, and unfortunately they don't make it. It is an organically human experience to carry the trial along and actually make it work. And caprice is always at the edge. I mean, pretty much any judge who has had any experience doing trials could tell you story after story of situations where the best laid plans jump off the tracks, and you have to drag the train back onto the tracks or start over. And that's all part of the process. And it's what I love. I love being a trial judge. It sounds like sour grapes. No one was going to make me put me on the Court of Appeals anyway, but that role is completely different from the trial judge, which it doesn't have the same performative aspect or just analyzing principles, and that's their job, to clarify them and make sure they're being applied properly. And it's an important job. But it's not nearly as much fun as being a trial judge and dealing with these things that we're talking about right now. And one of them is just the fact that life wriggles. It doesn't want to be under control, and your attempts to try to control it are always working against this topsy-turvy of actual life.
Yeah. No, if I may, I clerked for a district court judge in Philadelphia, and on top of the human, very human aspect of the job, and as well as the management part of the job with keeping the cases moving and so on. He also thought, I'm the boss here, and that won't be true if on the Court of Appeals. That is, we decide cases in three or more, and so he. Again, he may have had one or two conversations at some point, but he never took it seriously about, I'm happy where I am, thank you, and really enjoyed it.
No, I think that's probably pretty common among district court judges. I know, I was never, no one ever came sniffing around me to put me on the Court of Appeals. I'm out in Springfield. That's all going on in Boston. In the eastern part of the state. But I've had several colleagues who I can think of who had opportunities to go on the Court of Appeals and who just said, no, this is where I want to be. And being the decider, it reminds me, you were talking about Billy Budd and Herman Melville. When I'm thinking about Captain Ahab, there's one God in heaven, one captain of the Pequod, and one judge in this courtroom. And you are it. And there's something wonderful about that. But at the same time, it's the balance of that role. And it's an odd combination, because you can't lose your humility. You can't think you're too smart. You can't think that you're perfect. And at the same time, you have to have the ego to make the calls and make them stick. And your ability and power to make the calls and make them stick is at the heart of our system of justice, because if they can ignore you, the whole darn system falls down. There has to be a safe place where a person will make a decision and it will stick. And so you have to have the ego to do that. And at the same time, you have to try not to think too much of yourself. That's one of the reasons that I liked creating Judge Norcross. He's not I don't think I don't know. I'm still getting to know him, but I'm not sure that people would describe him as brilliant, or maybe not even a genius. I think they would describe him as intelligent. I think they would describe him as well-balanced, a good demeanor, good work habits, and a solid sort of person. And that, I think, is what most lawyers are looking for in a judge. The assistant U.S. attorney, who's a woman that I named Claudia Papadakis, is about to do her opening. And she's looking up at Norcross and she's saying, I'm glad he's on the case. He's a solid guy. Thank heaven he's not too in love with himself. And he doesn't have to always push himself forward and try and make clear to everybody that he's the smartest guy in the courtroom, constantly correcting people or fussing about there to draw attention to himself. But he's somebody that you trust. And Norcross is a decent person that way, a little boring. He's not someone with a zany sense of humor. He's not particularly playful, although he has a deeply loving relationship with his wife, and eventually in the third novel with his young son. So I'm trying to create somebody who has this combination of being able to be strict and clear and emphatic, and at the same time have some humility.
Yes. No, I think that really that one of the things that's conveyed is, and it's the most important thing, would be well, not just the fair shake, but also a respect for the process.
Yeah.
And again, that's when I've come to know several people who, are judges or have been judges. I feel like that's also essential to doing the job well, to
Mhm.
believe in the system and to not try and be either, too clever or clever by a half. That is,
Yeah.
there's a way we do things because that's the way we've decided that's the way they should be done. And it's your job to do them that way. And I mean that it sounds sort of obvious or even pedestrian, but I actually think that that's actually really true about, having taught civil procedure and so on, and having
Hmm.
myself, that's actually the older you get, the more I think you appreciate the idea of the system, whatever its flaws are.
Yeah. Yeah. I think you stated it perfectly. It is a system, and the role of the judge in that system is to. It's, I always tried to be as kind as I could be and be respectful, but you have to draw sharp lines and make things clear so that people know where they are. Well, one of the things that I tried to convey was just respect for the particular human being, whether they're a defendant or whether they're a civil litigant, either a plaintiff or just a witness who's scared out of their mind coming into this room with this giant ceiling and all these funny formalities, and just calming someone down and letting them know it's going to be okay. I'm not going to pull any fast ones on you. If you have any questions, you can ask me. We're going to move step by step here, and and hopefully that will calm people down so that they're not working so hard to avoid passing out or vomiting, that they're going to be able to listen to a question and answer the question reasonably clearly. And that's what you're trying to do. And it really comes back to the very first question you asked me, which is, what was I trying to do by making a judge the central figure of the story? And everything we've been talking about in the last hour or so has really, I'm just realizing, kind of ventilated that. The moral, physical, logistical, professional challenges of actually being in that role, which is so complex, and it's so much at the heart of how we work as a democracy. And it comes down in many ways to that man or woman doing their job well. Yeah.
I love the idea of closure. We've come full circle.
Yeah.
And so I think that unless you have anything you'd like to add, whether it's in response to anything that we've talked about or any of the questions, I'm prepared to conclude. That is to end. It's been wonderful. It's been enjoyable. I know I could go on, but I think this is actually a good place to stop.
I agree. This has been great. It's been really good to see you again, Professor, after more than 30 years, and to pick up. I've really enjoyed our conversation. Thank you very much for having me.
Thank you. Likewise, so much. Thank you.
Good night.